Sorry, how many minutes do you want?
Chair, we had prayed for 90 minutes.
Okay.
And you had granted it.
Very well.
We will share it with my learned friend, Mr. Sheikh.
Yes.
Abdikadir.
Welcome.
Mr. Harrison, is it correct that as Chief of Staff, you're part of the private staff of the governor? Yes. Is it correct, sir, that if the governor were to be impeached, you would lose the job you currently hold as Chief of Staff?
Is not correct.
Don't staff like yourself, don't their mandate terminate with the mandate of the governor in question?
No.
In the event the governor were impeached, would the new governor be entitled to appoint his own Chief of Staff?
Yes.
Therefore, you will not be the Chief of Staff.
I will not be the Chief of Staff, but I will be reassigned to other duties up to the expiry of my contract.
Yes, I'm only interested in your job as Chief of Staff. Wouldn't you lose that designation if the governor were impeached?
Yes.
Good. Wouldn't you lose the privileges that come with that designation if the governor were impeached?
Yes, I will lose.
Must it not therefore follow, sir, that even as the person you represent accuses several people of a conflict of interest, you actually have a conflict of interest in this matter?
I'm not.
Okay. You say, sir, in your affidavit, that you can speak to all the allegations, that is paragraph 3 of your affidavit, against the governor.
It's true.
You will agree with me that you're not the alter ego of the governor. Are you the alter ego of the governor, sir? I can put it in simpler terms. You and the governor are two separate and distinct human beings, correct or incorrect?
Correct.
Utterances made by the governor cannot by any stretch of imagination be your utterances.
I never talked of my utterances.
Please answer my question. The governor is accused of several utterances in various platforms. Your affidavit is you can speak to all the allegations against the governor.
Yes, I can.
Therefore, you will agree with me. Utterances by the governor, even though you are a Chief of Staff, are not your utterances.
It's true.
The things going on in the governor's mind at the time of making those utterances will not be also going on in your mind, correct or incorrect?
It is correct, but I need to say only God can know what goes inside someone's mind.
Fair enough. The motivations, whatever they are, in the governor doing any of the things she is alleged to have done will not be your motivations, because you and the governor are different persons. Correct or incorrect?
It's correct.
You must agree with me, therefore, that you're not competent enough to respond. That is what you pleaded in paragraph 3 of your affidavit. You must agree with me, you are not competent, as you claim, to respond to all the allegations against the governor.
Through the chair, I also need to say this. When someone is represented by a lawyer like you, there is a possibility that when you get the information about what your client is for, you find that information, and even you, currently, you are engaged on the information that you got from your client, and that's why you are representing you. Because for sure, even you, I'm very sure, you cannot know what was the mind of the person or the mover of the motion. We are here as witness and to represent our client because the law allows us to do that.
Chair, since the witness will have the opportunity in re-exam to explain, I crave that you direct him to just answer my questions so that I don't take longer than the time you have allocated me.
I think a witness, that is important. Make sure that your response is directly in proportion with the question.
Noted, Chair.
The governor has faced a number of accusations, sir. Let's begin with the appointment of the husband. Is it your position, sir, the governor never made the utterances we saw on video are making?
She made the utterances.
Good. So the only difference between you and me is our interpretation of those utterances, isn't it?
Yes, through the chair, the utterances are not in dispute to any party.
So do you agree with me that the only contest between the two sides is not whether the utterances were made, but how we have interpreted them vis-a-vis how the governor has interpreted them?
It's true.
You will also agree with me, sir, that the second point of departure is not whether the utterances were made, but whether they were followed by official letters of appointment.
That's true.
Sir, would you expect people watching the governor making utterances of the type she was making to take them seriously?
Pardon?
Would you expect the ordinary citizen to take utterances by the governor seriously and specifically on their face value?
Yes, I do.
If the governor announces on national television or regional television that she has appointed her husband to some office, would you expect the ordinary rational person to take her seriously?
I expect to be taken serious. I want to add, there is no denial that she intended that.
Order witness. Counsel, help us. You cannot expect the witness to testify on the opinion of other people. Limit him to his evidence and poke holes in his evidence. But to ask him now to give us an opinion on what he thinks the whole county was thinking, we shall be stretching him.
Let's come to our point of divergence on the issue whether the appointment letters were issued.
They were not.
Are you a member of the County Public Service Board, sir?
I'm not.
Are you the county secretary?
I'm not.
You must agree, therefore, you would not be the person to give the best evidence as to whether the appointment letters were issued or not.
Through the chair, I intend communication to all those offices, and the letters or their responses have been attached to the response that governor gave. So my responsibility was to do an investigation of which I intend, because I cannot be everyone, I cannot be every person, but those persons that are responsible, I intend my duty, and they confirmed the same.
Chair, if my colleague could show the witness volume 2 of our battle at page 29.
Council, are you referring to your bundle or ours?
Ours, volume 2.
You can share yours. We do not seem to have it here.
What you have there, sir, before you is a printout of section 56. My interest is in subsection 2 of the County Governments Act. Can you read it for us?
The county public service shall be ended by a county secretary appointed under section 44.
You will agree, sir, that is the person competent to confirm to this Senate whether there is an appointment letter or not.
Through the chair, if you look at all the letters were copied to the county secretary to
That's
confirm.
not my question, sir. Based on that section, wouldn't the county secretary be the person legally qualified to tell the Senate whether or not an appointment letter was issued?
Probably it is good to differentiate between the office of the governor and the county public service. There is a difference.
I didn't ask about the differences. Please answer my question. If you don't want to answer it so that we move fast, just say you don't want to answer my question.
County secretary can confirm about the public service, but the chief of staff confirms about those that are employed in the office of the governor.
Are you aware the motion is about appointments to the county public service, not to the private office of the governor?
It is misplaced because the people that were mentioned are supposed to be those people in the office of the governor.
Let's come to the office of firefighters in the county government of Meru. Is that would that be an appointment in the office of the governor?
Yes, it is.
I put it to you, that, sir, that it is not. There is a firefighting department. It is not an office in the private affairs of the governor like the advisors and the chief of staff like yourself.
You can confirm for Meru County is a department that was put under the office of the governor. You can confirm.
The Meru Youth Service, is it a body created by law?
Yes, it is.
Does that law specify the offices of that institution?
Yes, it is.
Now that you say there is no dispute, the appointment was declared, is the office, are the offices in the Meru Youth Service offices in the private office of the governor? Is that your testimony?
My testimony is that what you're discussing is about the appointment of the first gentleman to an existence position. So the position is nowhere. It is not either under the public service or in my office. I needed to confirm that it is not in my office because on an existing position, you cannot put it anywhere.
But you confirmed the utterances were made in the rally in question, isn't it?
Yes, I confirm.
Those utterances, wouldn't they, if they were to be taken seriously, be violative of the law establishing the Meru Youth Service?
It is not related to Meru Youth Service in any way. That's my take.
To the best of your knowledge, sir, does the law establishing the Meru Youth Service have the office of patron?
It has not.
It has not.
Yes.
Still on the letters, sir, who ordinarily would be the custodian of the appointment letters if they were issued?
The Public Service Board.
The Public Service Board.
Yes.
Who else would be having possession of such a document?
Myself.
Yes.
Yes.
Who else? The appointee in question, isn't it?
Yes.
You'll agree all these are people naturally aligned to the executive arm of the government, right?
Yes.
Good. You will agree matters to do with employment and HR, the assembly will not ordinarily be in possession of appointment letters of staff of the executive.
Through the chair, the responsibility of proof lies with the county assembly because they have powers to summon everyone to get that details.
My question is, in the ordinary course of human affairs, would a stranger be in possession of HR documents like an appointment letter?
Any public document is available on request.
Good, on request. Therefore, sir, you will agree with me, there is nothing unusual in the ordinary course of events in the assembly either not having possession of the appointment letter or encountering difficulties in accessing it.
Pardon?
You will agree with me, it is not unusual for the assembly not to have in its possession appointment letters belonging to staff in the executive arm.
I don't agree because an ignorant to the privilege that you've given cannot be a defense.
Chair, again, if the witness would answer my questions, I think he's too keen. He doesn't know you'll have the opportunity. I don't want to be making the interjection. Let's go to the appointment of Rufus Miriti. We've now left the husband. You will agree with me, sir, that the only contest between the two sides is not whether the appointment was made, but whether it required the approval of the assembly. Am I correct to say that?
You are correct.
Is it your case, sir, that that approval was not required?
It was not required. It was just a reappointment that has ever happened in other situations.
I will ask you, sir, to read the definition of appointment in the County Public Appointments County Assembly Approval Act. Chair, that will be at page 48 of our volume 2. Have you reached page 48, sir?
Yes.
Can you read for us the definition of appointment at section
For which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act.
So the law says an appointment for which approval is necessary shall not be made unless the approval is sought, isn't it?
It's true.
But you read section 4, you were ahead of me. I asked you to read the definition of appointment in section 2 on the same page. Please read what I asked you to read.
Appointment includes any reappointment to the same body where or not in the same capacity.
You will agree these sections show, contrary to the position you and the governor have taken, that this appointment which you concede was made actually required the approval of the assembly. By the law you've read, was that approval required?
It was required.
Good. If it was required, was it sought?
I need to emphasize on this through the chair.
Please answer my question. It's yes or no. You have agreed the approval was required. Was it obtained?
It can only be required when it is
yes or no, unless the chair rules me out of order. Was it obtained or
it
not?
was not obtained.
Good. It was not obtained. I will show you page 186. You just read the statute. We now want to see what the courts have ruled on the matter. Chair, I'm referring to volume 2 of our Bible, page 186. It's a decision, Chair, that begins at page 170, but I'm only interested in the conclusion the judge arrived at, which is at 186.
Honorable Chair, your kind permission.
Yes, what is it?
Honorable Chair, the concern is that this witness is being taken through a course to offer opinions on possessions of the law. I think that is a matter for lawyers, and he should first of all have confirmed whether he tackles or handles matters of law in the office he said he serves in the county. Now he's being told to interpret a judicial decision, which, my Lord, may not be within his competence, because it's a matter of law, and any other witness, including the governor, would not have testified to that because it's not a factual matter. It's a matter of law. I think the witness is being oppressed to be required to offer a legal opinion. He has no training in law, my Lord. Thank you.
Counsel, don't overprotect your witness. Your witness is a very competent man. I think what the counsel for the county assembly is asking for is not a point of law. He's not even seeking an opinion. It's a fair question. Let the answer be on record. We shall interpret it. Don't overprotect him. He's above 18.
Most obliged, sir.
Through the chair.
Even asked you the question, sir. Please read for us paragraph 105 on page 186. It's a matter about a county assembly appointment, just like the one now before us. Please read it.
Paragraph
105.
It was, however, contended that since some of the petitioners had been approved by the previous assembly as the first respondent and its predecessor were